Article 137 Duress Canon 2365 Duress or coercion is any threat, fear or inducement directed against a person to act or refrain from acting in a manner they would otherwise not consider in the absence of the threat, fear or inducement. Canon 2366 Any consent granted under duress has no effect and is null and void from the beginning. Canon 2367 Any agreement sealed and consented under duress has no effect. Canon 2368 Any testimony given under duress has no validity and cannot be used as evidence in any competent forum. Article 138 Perfidy Canon 2369 Perfidy is the deliberately deceitful act of falsely making a promise, a vow, allegiance or agreement for the purpose of gaining proximity and trust in order to undertake an act of treachery and great injury. Canon 2370 Perfidy is one of the most heinous acts against the law and society in that a person deliberately uses the good faith and trust of others against them, thus creating confusion, further mistrust and turmoil. Canon 2371 Of all the persons and inferior juridic persons that have existed, there exists two classes of persons who have consistently demonstrated continued acts of perfidy against virtually every society and community, with apparent immunity within the framework of inferior Roman law, the banking class and the bar associations. Canon 2372 The banking class of families sharing a long history of creating, owning and controlling financial institutions are the single greatest source of acts of perfidy than every other class of professions and persons combined, excluding the bar associations. As a result, this banking class sharing common ancestry and cultural heritage have been responsible for more wars, genocides, recessions, depressions and global misery than all the worst dictators of history. Canon 2373 Second to the banking class of families, the bar association is the second greatest source of acts of perfidy, usually working closely in support of the banking class. Canon 2374 In accordance with these canons in the Sacred Covenant Pactum de Singularis Celum and as penalty for their historic perfidy, no person whose father, grandfather or great-grandfather was a major shareholder of a bank is permitted to hold any position of any financial institution, nor may any of their family be involved in banking for 7 generations that follow. Canon 2375 In accordance with these canons and the Sacred Covenant Pactum de Singularis Celum and as penalty for their historic perfidy, no person who is a member of a bar association is permitted to hold any position at law including judge, magistrate, barrister, attorney, lawyer, clerk or assistant. Article 139 Default Canon 2376 Default is the failure of a person to appear and defend an accusation, thus causing a judgment or action to be rendered against them. Canon 2377 The failure to meet an obligation of an agreement is a breach, not a default. A breach of agreement is not equivalent to a default. Canon 2378 Excluding any lawful excuse or obstruction, a person or their counsel is expected to appear before a competent authority where an accusation or controversy against them has been raised. Canon 2379 Excluding any lawful excuse or obstruction, a person who fails to attend a hearing before a competent authority admits their guilt. Canon 2380 Excluding fraudulent causes or action or errors of due process, the failure of a person to appear before a competent authority when called to answer and defend themselves causes an injury to the law. Canon 2381 When a person has caused an injury to the law and admitted their guilt through non-attendance, a competent authority may then issue an order against the person known as a default judgment, compelling the person to perform the obligations of the order. Canon 2382 Any person who issues a default notice or judgment before a person has had the opportunity to defend themselves is guilty of fraud and deception and automatically consents and affirms full liability of the default judgment, plus any further penalties and punishment. Canon 2383. A default notice or judgment can never be issued unless a person has been given the fair right and notice to defend themselves before a competent authority. Article 140. Alteration. Canon 2384. Alteration is when a material change is made in a form leading to a change in condition, status or its nature. Canon 2385. A material change is a deliberate action capable of being identified and proven as an alteration to an original form. Canon 2386. The form of an agreement can never be altered without the expression written permission of all the parties. Canon 2387. The alteration of a form of an agreement without consent constitutes fraud. Canon 2388. The terms of an agreement can never be altered without the express written permission of all the parties. Article 141. Deviation. Canon 2389. A deviation is fictional concept whereby a voluntary and unnecessary departure of a vessel from, or delay in, the regular and usual course of the specific voyage insured, permits the underwriters to be released from their responsibility. Canon 2390. In inferior Roman law that applies the laws of the sea upon men and women as flesh vessels, deviation is often used by underwriters to secure release via inferior Roman courts of their obligations. Canon 2391. The application of deviation to any person as a means of reducing or releasing liability by an underwriter constitutes fraud where such disclosure of techniques is not first clearly stated upon the terms of the agreement. Article 142. Mistake. Canon 2392. A mistake, also known as a mistake of fact, is an erroneous belief or trust that certain facts are true when committing a reasonable action. A mistake of fact does not exist when an action is considered unreasonable. Canon 2393. A reasonable action in terms of a mistake of fact is any action that one would expect to represent the norms of respectful society and behavior, thus excluding such actions as violence, depravity, perfidy, fraud and other acts considered universally as antisocial and grossly disrespectful. Canon 2394. A mistake of fact is not permitted to be argued when the alleged actions by the person are grossly unreasonable. Canon 2395. In the permitted admission of a mistake of fact, any assumed surety for liability from alleged injury ceases to exist. Canon 2396. A person is not considered to consent who commits a mistake. Canon 2397. Any person permitted to admit a mistake of fact must be offered relief to any alleged injury in addition to cessation of any claimed surety for any liabilities associated with the alleged injury. Canon 2398. Any competent authority that refuses to release a person from surety for any liability upon a permitted admission of mistake of fact fully consents to assume the liability for themselves. Canon 2399. Any competent authority that refuses to offer relief to a person upon a permitted admission of mistake of fact is guilty of fraud and a gross injury to the law. Canon 2400. When a person has been deliberately deceived by fraud, then neither mistake nor injury exists. Canon 2401. Excluding fraud, consent obviates a mistake. Article 143. Frustration. Canon 2402. Frustration, also known as frustration of purpose, is a fictional concept whereby an unforeseen event delays, impedes or prevents the performance of a primary element of an agreement which both parties agreed represented a principal purpose of the agreement. Canon 2403. Principal purpose of an agreement in relation to frustration of purpose is any intrinsic element of the agreement of such importance that neither party would have entered the agreement in the first place in its absence. Canon 2404. Frustration is not equivalent to impossibility even though both concepts relate to unforeseen events. Impossibility concerns unforeseen events and the duties specified to be performed in an agreement, whereas frustration concerns any unforeseen events and the reason a party entered into the agreement. Canon 2405. Where an agreement has not made provision to exclude certain unforeseen events, The defense of frustration may be argued as a lawful defense for non-performance of duties under an agreement for those events not otherwise excluded. Canon 2406. No mercantile agreement may seek to exclude force majeure as a defense for frustration and as a lawful excuse for non-performance. Article 144. Impossibility. Canon 2407. Impossibility is a fictional concept whereby an unforeseen event makes performance of the terms of the agreement impossible. Canon 2408. Unforeseen event. In relation to impossibility is any change in circumstances such as in force majeure, discovered pre-existing condition, death or disablement or other event of such major significance that there is no way to continue to perform the agreement. Canon 2409. Where an agreement has not made provision to exclude certain unforeseen events, the defense of impossibility may be argued as a lawful defense for non-performance of duties under an agreement for those events not otherwise excluded. Canon 2410. No mercantile agreement may seek to exclude force majeure as a defense for impossibility and as a lawful excuse for non-performance. Article 145. Impracticability. Canon 2411. Impracticability is a fictional concept whereby unforeseen circumstances make performance of the terms of the agreement unreasonably difficult or unviable for the party obligated to perform. Canon 2412. Unforeseen circumstances. In relation to impracticability is any change in circumstances that were not anticipated nor included in any of the terms of the agreement. Canon 2413. Unreasonably difficult or unviable. In relation to impracticability is a change to the conditions of performance of the agreement that place an unreasonable burden on a party that may also render performance unviable for the party. Canon 2414. No mercantile agreement may seek to exclude the right to claim relief through the defense of impracticability. Canon 2415. The claim of relief through the defense of impracticability does not excuse non-performance, unless no relief is properly offered. Article 146. Unconscionability. Canon 2416. Unconscionability is a fictional concept whereby a party may seek defense against the enforcement of an agreement based on the presence of terms and consideration that are excessively unfair to one party. Canon 2417. Any valid agreement must pass a basic test of fairness wherein no party may take excessive advantage of the circumstances of the other so that any consideration offered or terms provided are manifestly biased and unfair to the other party. Canon 2418. Unconscionability is equivalent to exploitation whereby a party exploits their superior position to seek to lawfully gain an unfair advantage over the other party in a significantly inferior position. Canon 2419. Consent of the lesser party to the original agreement and the cause of action are immaterial to testing an alleged unconscionable and exploitative agreement. Canon 2420. A competent authority is permitted to render any agreement found to be unconscionable and exploitative unenforceable and therefore null and void. Article 147. Misrepresentation. Canon 2421. Misrepresentation is when one party of an agreement makes false and misleading statements of fact to the other party in order to induce an agreement or secure some other advantage. Canon 2422. Misrepresentation is equivalent to fraud in the effect that once proven, it causes the extinction of any contract with forgiveness of all obligations and debts of the victim. A competent authority may also award further damages against the party guilty of misrepresentation. Canon 2423. False and misleading statements of fact in reference to misrepresentation are required to be proven to be deliberately and knowingly false, done with the intention of inducing a party to contract or secure some other defined advantage within the agreement. Canon 2424. Silence is to be regarded as a potential form of misrepresentation. Lack of full disclosure is also to be regarded as a form of misrepresentation. Canon 2425. A technical distortion of fact may not of itself be sufficient proof of misrepresentation when it can be shown to be a mistake of fact. Canon 2426. Unless concealment by silence or lack of disclosure can be shown, a change in circumstances between an offer, or a consideration and a final agreement before consent is not of itself sufficient grounds for misrepresentation. Canon 2427. The use of terms without proper disclosure as to their legal effect is a form of misrepresentation. Canon 2428. Any mortgage agreement that fails to properly disclose the financial institution as landlord, the borrower as tenant and the agreement as a lease, with interest payments being rent, is a form of gross misrepresentation. In accordance with these canons and pactum de singularis caelum, all such agreements are hereby summarily rendered null and void, with the offending financial institution accepting full liability and obligations for their deliberate misrepresentation as penalty. Article 148. Concealment. Canon 2429. Concealment is the deliberate obscuring of one or more attributes of a form by rendering its identification from view inconspicuous, deceptive, camouflaged, or all three. The most common purpose of concealment is secrecy. Canon 2430. Concealment is equivalent to hiding a form in plain sight. Canon 2431. Concealment is a form of deliberate misrepresentation rendering any agreement null and void. Canon 2432. The most ancient model of concealment is with information in which an encoded message of true information is concealed in a random or meaningless set of statements or characters. A key or cipher is then needed to unlock the concealed information and extract the truth. Canon 2433. As all complex systems may be resolved to a few simple axioms, it has been a tradition that the most important and powerful forms of knowledge and ideas by which a society functions are deliberately concealed from all but a few who possess the right key. Canon 2434. The symbol of the key is the most common symbol signifying true knowledge from false knowledge on account of the ancient tradition of publishing deliberately false knowledge in which truth is concealed in plain sight. Canon 2435. Concealment is a form of fraud. Canon 2436. The most common use of concealment is with knowledge, most specifically those forms that constitute foundational ideas upon which major elements of society function. As the true knowledge is hidden amongst deliberately false knowledge, the ability to decipher is rendered extremely difficult without a key to unlock and extract the truth. Canon 2437. The inferior Roman legal system is deliberately complex with volumes of texts in order to deliberately conceal, confuse and ensure knowledge of the law is excluded for all but a very few. Canon 2438. As it is a primary objective of the inferior Roman legal system to conceal, defraud and usurp the law, in accordance with these canons, all inferior Roman legal dictionaries, texts and books hereby hold no lawful value nor merit other than their historical interest in how men and women were denied access to true law for so long. Canon 2439. The inferior Roman finance and banking system is deliberately complex with volumes of statutes and procedures designed to deliberately conceal the nature of trade and use of value to all but a very few. Canon 2440. As the statutes of the inferior Roman finance and banking system is predicated on fraud, no contract or negotiable instrument issued under Roman finance law can possibly claim to be valid unless by acknowledging the supreme authority of these canons, the superiority of the supreme financial system and the sacred covenant pactum de singularis caelum. Article 149. Extinction. Canon 2441. Extinction is the cessation of one or more obligations of an agreement, covenant, deed or contract or the contract itself. The concept of termination may also be applied, but also to the whole agreement itself in accordance with its clauses or some fundamental breach which renders the agreement or covenant inoperable. Canon 2442. It is a fundamental principle of all contract law that once enacted, contracts are to be honored and performed. Canon 2443. Excluding clauses within the agreement or covenant which denote the conditions by which part or all of the covenant may terminate. The most serious condition for extinction and termination is a repudiatory breach, also known as a fundamental breach. Canon 2444. A repudiatory breach is when a party or designated agent or successor is guilty of such a fundamental breach of the essential terms of a covenant that no remediation may adequately repair the injury, or key elements of the covenant are rendered inoperable. In such circumstances, the distressed party is permitted to terminate performance of the covenant in addition to entitling that party to pursue punitive action for damages. Canon 2445. The most serious of all repudiatory breaches is when a covenant between divine or demonic spiritual forces is breached by the agents or nominated successors of its foundation. In the history of civilization, the most serious and significant repudiatory breach of this kind is the extinction of the Talmud and Talmudic law in the 20th century by false representatives of the Menashe who caused several fundamental breaches of this agreement. Canon 2446. In accordance with divine will, divine law, natural law, positive law and all principles of contract law, all who claim to remain party to the covenant of the Talmud and its inclusion in the Bible are hereby terminated from all authority or rights to claim. Instead, all rights to this covenant have been lawfully transferred to the Society of One Heaven in accordance with the sacred covenant Pactum de Singularis Caelum.